Capacity of parties refers to competency of parties to enter into a contract. Section 11 Contracts Act 1950 provides that every person who has reached the age of majority according to the law which he is subject and who is sound mind and not disqualified from contracting by any law is competent to contract. According to Section 11, competency depends on 1. Age, 2. State of mind, 3. Disqualification by law, not to be discussed. Mohari Bibi v. Dermodas Gos, 1903. An infant entered into a contract to get a loan from the appellant. Later, the infant commenced an action through his mother for a declaration that the contract was void for lack of capacity. Court held that the contract was void because a party to the contract is an infant. AG. Age required under the law is the age of majority. According to Section 2, Age of Majority Act 1971, the age of majority is 18 and above. The person is called a major. Those who is below 18 years old is a minor. The general rule is that all contracts entered into by minor are void. Reason for this is to prevent the minors against any consequences of its own action. Tan He Juan v. Boon Keat, 1934, it involved a transfer of land. The plaintiff, who was an infant minor, executed transfers of land in favor of the defendant. Then the plaintiff, by his friend, applied to court an order setting aside the transfer for incidental relief. Court held that the contract was void on the ground that the party to the contract was a minor. Exceptions to the general rule. 1. Age of Majority Act 1971. Contracts Act 1950. 1. Under Age of Majority Act 1971. 1. In matters relating to marriage, divorce, dower, and adoption. 2. In religious matter. 3. Any other law fixing the age of majority, age is 21 years for voting. Rajaswari and Anor v. Balakrishnan and Ors, 1958. A promise of marriage entered into by minor. The agreement was entered into with provisions for dowry and penalty for breach. Then the promise to marry is repudiated. The plaintiff sued for breach of promise to marry. The defendant pleaded that since the plaintiff is a minor, then the agreement is void. Court held that the marriage contracts entered into by the minors was valid. Since one of the parties breached the contract, the other party has the right to sue. 2. Under Contracts Act 1950. 1. Necessities. 2. Scholarship. 3. Insurance. Necessities. What are necessities? Necessities are minors' actual needs and his station in life. For example, clothes, food, education, shelter, transport, etc. Section 69 Contracts Act 1950 provides that contract with a minor is a valid contract provided that the necessities must have been supplied to a minor. Agreement to supply is void. The minor's liability includes necessities supplied to anyone whom he is legally bound to support, such as wife or child. The supplier of necessities may claim only a reasonable price, which may not be the same as the contract price. Minor will only pay if he has the property to do so. Nash v. Inman, 1908. The defendant is a minor. He ordered certain clothes from the plaintiff, including 11 fancy waistcoats. The plaintiff sued the defendant to recover the cost of the clothes supplied. According to the evidence given by the minor's father, the minor already had adequate supply of clothes suitable and necessary for his condition in life. Court held that since the clothes supplied by the plaintiff were not necessities, the minor should not be liable for the clothes. Government of Malaysia v. Gucharan Singh and Ors, 1971. The defendant was sued for the amount of $11,500 alleged to be the sum actually spent by the government in educating the defendant. The defendant argued that at the time of the contract, the defendant was a minor. Court held that the contract was void, but since education was necessary, the defendant was liable for the repayment of a reasonable sum spent on him. Scholarship Section 4A Contracts, Amendment Act 1976 provides that no scholarship agreement should be invalidated on the ground that the person entering the contract is a minor. Insurance under the Insurance Act 1963, revised 1972, a minor over the age of 10 may enter into a contract of insurance. If under 16 years, then the consent of the parents or guardian. State of Mind, Section 12(1). Contracts Act 1950. A person is said to be of sound mind for the purpose of making a contract if, at the time when he makes it, he is capable of understanding it, and of forming a rational judgment as to its effect upon his interests. According to Section 12(1), a person who is competent to enter into a contract is a person who is of sound mind. The person must be capable of understanding the contract and form a rational judgment upon its effect. The person who is not of sound mind, incapacity refers to person who is mentally disorder, and also those who is incapacitated through sickness, alcohol, or drugs. Section 12(2), a person who usually suffers from mental disorder may make a contract during those periods when he is sound. A person who is mentally disordered can make a contract at a time when he is sound. Section 12(3), a person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. A person who is sound cannot make a contract when he is not sound. Example: drunk, sick, or under influence of drug. Effect of contract. The Malaysian law is silent on the effect of the contract. However, the English law treated the contract as voidable.